So whether a creditor decides to pursue a PJR or not, the next step is the actual collection lawsuit itself, which is comprised of the various legal steps. The first step is the complaint, which outlines the elements of your claim to establish that you are owed money and how much. Thereafter, if the debtor contests your claim, they will file an answer to the complaint. From there, both parties will have the right to do discovery, and once discovery is completed, the parties will be entitled to their day in court, in other words, a trial. And Alena, generally speaking, from beginning to end, would you agree that normally a collection case takes 1 to 2 years in Connecticut?
Yes, that's generally accurate, but it does depend on what court you're in and how crowded the dockets are. So now you have your judgment. What can you do with it? Enforcement of a Connecticut judgment is also mandated by statute.
This is the collectability component. This is in fact the most frustrating and time-consuming part of a collection case. Once you have your judgment, it is simply a piece of paper. The court cannot order the debtor to open their checkbook and write you a check. If the debtor does not want to voluntarily pay you, you have to follow the mechanisms under Connecticut law to locate and liquidate the assets of the debtor in order to satisfy your judgment.
A creditor should know at this point whether the company is in business, where they do business, what customers they might have, and what property they might own. This is also the time a creditor can perfect its prior PJR liens. Another option is to conduct post-judgment discovery of a judgment debtor.
And Alena, very importantly, it is not so much asking what assets are there today, which needs to be asked, but what assets the debtor may have transferred out of its or his or her name in the last 4 years. Many times I find that it's not so much what's left there today, but what was once there. This is extremely important and needs to be investigated because there are laws to permit a creditor to undo these transfers, and that law is called fraudulent conveyance or fraudulent transfer law. For example, we see many times in a collection case that the house was once in the name of the debtor, but fearing a collection lawsuit might be coming or has been commenced, they will quit claim that house into the wife's name. This could easily be avoided under fraudulent transfer law.
Bob, one point on this is it's very important to pursue a fraudulent transfer action in a timely manner.
Alena, you have your judgment and you've located some assets. What other steps can a creditor do in Connecticut to collect?
Creditors can record liens against real and personal property and can attach or garnish bank accounts. If the debtor is a company, a creditor has the right to seek a charging order. Further, once a creditor has a judgment, it can seek an award of post-judgment interest and can request an order to recover all the costs and fees of post-judgment collection.
Alena, the judgment itself is good for 20 years. You never know what change in circumstances may arise over those 20 years. If you are a creditor who is looking for legal assistance in collecting monies owed in Connecticut, please do not hesitate to contact us. We have the experience and the ability to help you.